Hello everybody, and welcome to the third MyHR Summit series. As you know, this is the fallback from our actual live face-to-face summit that we'd scheduled at Villa Maria and sadly had to cancel just with the up and down of the lockdowns. At level 3, we couldn't host. At level 2, it was really impossible to, and we just didn't know what state Auckland would be in. So we've opted to do this instead. The take-up's been amazing. We've had over 400 people attend already. So I think there's a real interest in this. And so we are definitely going to do these again, I think, but also revisit the summit. And at a time when we're all safe and through this crazy COVID time, get back together in a room and do this thing face to face. So today's session is an employment law update. My esteemed guest is Jennifer Mills, who, from my view, is New Zealand's best employment lawyer. Thank you for joining us, Jennifer. I've known Jennifer for a while, and she is awesome. One of the things we did when we reviewed what we were going to talk about today was sort of look at some of the headline changes in legislation, but then also what's actually playing out in reality. And a good place to look is the Employment Relations Authority to see how authority members or employment court judges are ruling on the activity or the actions of employers. Because the big law changes this year all sort of centre around the Holidays Act, and last week was the Holidays Act session. So this session, Jennifer and I have decided to focus on some of the headline cases and what they mean for you as employers, to talk a little bit about the rise in grievance activity that we have seen, and then answer your questions as we go. As you know, I'm an advocate for you asking questions as we roll, so we can just build that into the session. But of course, there is time at the end too, if you want to. I will keep an eye on the chat portal here in Zoom and make sure that I get to your questions. So I'm going to share the screen and just take you through our agenda. Okay. So this is today's session. So we're going to talk a bit about the increase in grievance activity. There is the Metropolitan Glass case, which I think is really important, and Jennifer's going to speak on that. She has some insights. Jen, I might sort of jump in and ask you some questions about that too, because this is a topic that we find often comes up when our clients ask us to create employment agreements for them, and we have discussions about discretionary versus non-discretionary bonuses. The liquor stores piece is interesting. There's been a bit of a target on them recently, and you'll find the Labour Inspectorate does this. They sort of look at industry sectors. A few years back, it was primary industries, particularly the fruit pickers and some dairy farms, and there's been a run on liquor stores. And so what we're finding with those, and the Bruce Campbell Value Tyres case, which is a redundancy one. And there's some significance there in terms of the scale of the payout or the award, and the reasons why that employer had to pay out. And then we'll just talk through some tips on handling problems in the workplace. So Jennifer, how about I hand over to you if you'd like to talk to this first slide.
I think this is your slide, Jace. I pick up at Metroglass.
Oh, good. Excellent. Okay. So this slide, these stats are really quite telling. And what's interesting about it is anecdotally, or I guess not so anecdotally, because we are at the front line, we have seen a massive increase in the raising of personal grievances. And this data that you're seeing here from the Ministry of Business, Innovation and Employment backs that up. But we're finding employees more and more willing to have a crack. And sometimes there is really no basis for the grievance whatsoever. And so we engage in a process. Let's take redundancy process as an example. There is a solid and sound commercial justification for the redundancy. There is a full and fair process followed. There's a lot of effort put into redeployment. And at the end, having found no suitable alternative employment and confirming a termination through redundancy, we see a grievance will still bounce back. People are just having a crack is something that we have noticed. And so we're building into our own processes this sort of preparation for that and this awareness of that. One of the big things that we've obviously has happened in the last year is the effect of lockdowns on workplaces, the inability to work, and what do you do? Sending people away, forcing people, in inverted commas, to take leave, or lack of consultation around change of hours and those sorts of things. So this really for you as employers is to let you know that there is an increase in grievance. There are people out there who are willing to have a crack kind of no matter what. And in some instances, they are genuine, no doubt. But certainly, more and more people are prepared to have a go. And I think partly it's an uncertain work environment. So they'd much rather hold on to their job and fight for their job. So nice to see the data kind of backs up our experience. Jennifer, have you got anything to say around this? And in terms of your role as a lawyer in defending employers, does your experience back this up, or have you found it to be fairly steady?
Yes, well, certainly the data that we've had a look at shows that the nature of the claims, bullying, harassment, discrimination are on the rise. So specifically, there's an increase in that area, and our practice has seen that as well. And at the moment, as it would transpire, we've got a very large sexual harassment issue within a significant technology corporation based in New Zealand, and the allegations are widespread throughout the entire business. So we are certainly seeing more of these cases, and the data also shows that more broadly there was an increase in personal grievances due to the COVID-19 pandemic and the lockdown. And we've seen, obviously, the nature of those cases are unjustified dismissal by reason of redundancy type personal grievances. So we're seeing that employers have had to urgently restructure their business to survive in this new world. And some employers certainly haven't followed a fair and full process to get it right. So it seems to be a consistent theme with what you've seen, Jason.
Yeah, and I think that's really interesting. One of the things we're really clear on with our clients is COVID-19 is not a justification for redundancy, right? COVID-19 is a thing that has happened, that has affected our business community and our community at large. And as a result of that, commercial impacts have occurred in your business. Those commercial impacts are the things that justify the redundancy. And I've certainly seen, I think that's where these redundancies are found to be wanting, is that the basis of the commercial justification is pretty weak, because the employer has just sort of gone, well, hey, it's COVID, we ran out of clients, or there was a lockdown, therefore I can't support the role anymore. You still need to provide a sound and solid commercial justification. You can't just blame COVID as a headline statement. I think that's a takeout. With the bullying thing, Jennifer, I wonder, the authority used to be, I think, somewhat sympathetic when you pursued disciplinary action and an employee responded by saying, I'm being bullied. And that where it was clear that there was actually genuine grounds for the disciplinary, that the authority would sort of go, look, this is not bullying, this is just genuine performance management. Is that still the case?
Oh, it's a common tactic. So there are performance concerns, the employee's response is that they're being bullied, as opposed to they're actually being managed appropriately in accordance with a performance improvement plan. So we often see that. We often see where it's coupled with poor performance, there's a retaliatory type nature, but the authority and the court are pretty alive to that. Okay. The only other point that I wanted to make on the COVID-19 is not a commercial justification for redundancy in itself. Just to be aware that the courts now are looking at the genuineness of commercial justifications for redundancy. And if you are going to be precise in terms of what cost savings you might be looking to achieve, they need to be accurate. And there are a number of recent cases where the courts have said, look, that's miles from what's accurate, and it's simply not genuine, even though you can see as an advocate, you feel a bit sorry for the employer because they've clearly needed to restructure their business. They ought to be entitled to manage their business as they see fit. But if they get the substantive justification wrong, or the cost savings aren't accurate, then the redundancy is unjustified.
Yeah, that's great to hear. I mean, that's something we try to advise as well. And there are a few cases. I'm probably not quite the case law encyclopedia that you are, Jennifer, but I do remember, I think there was a Tauranga-based or Bay of Plenty-based accountancy firm that were pulled up on something similar. The commercials they relied on were nothing compared to, it didn't really relate to what they'd said when
that's exactly right.
Had a look at it. They went, actually, there's a discrepancy here. And also, there's not just the accuracy of your commercial justification, but the sharing of that, this idea of what is commercially confidential now, you know, if it forms part of the decision to terminate the employment, then the employee has an entitlement to see it. And so if you have concerns about the commercially confidential nature of it, you can request NDAs, you can operate in a sort of closed room type environment, but the employee and their representatives need to see everything. Would you agree with that?
Well, if you're relying on it to justify a redundancy, absolutely. But the obligation of good faith in terms of consultation has a carve out in relation to commercially sensitive information where it's confidential. But that's more in a business acquisition and business sales scenario rather than using it to justify a redundancy for an employee. It goes broader. It's broader than that. It's broader than good faith. It's also a matter of natural justice, frankly.
Yeah. Okay. Awesome. I get the feeling we could talk about this for the entire.
Yes, let's move on.
I'll move on. I wish we were at the Villa Maria because we could just riff and have a great time. Please, folks, feel free to ask questions as well. I'm going to jump on to the Metroglass case and hand over to you, Jennifer, because this is a really interesting one.
Thanks, Jason. Just be mindful that you're in charge of these slides.
Got it.
So just as an overview, I don't propose to go through this in the time that we have, but the Act sets out a highly prescriptive approach to calculate leave entitlements, and why it's relevant to you is because you're looking at a potential exposure of up to 6 years. And the Holidays Act is still in force. We know from the task force report, and you would have had that session last week, that the government has endorsed the change for the calculation of both annual leave and BAPS leave, and it's going to get worse. Currently, it's the greater of average weekly earnings and ordinary weekly pay. In the future, it's going to be the greater of 4 separate calculations when you're looking at how to calculate annual leave. But for now, payroll are still grappling with the greater of these 2 calculations. That's why it's relevant. It's still the law, and you could have a potential ongoing 6-year claim going back 6 years from date of an employee's termination. Now, the case dealt with a number of issues, one of which was close downs, and that I'm not going to talk to that today, and the other was the meaning of gross earnings and whether a discretionary short-term incentive scheme formed part of earnings which ought to be treated as gross earnings for the purposes of the calculation of annual leave. Now, what I was frankly surprised at the decision. The STI was in a separate document. The scheme was drafted as entirely discretionary and that no monies could be paid under the scheme. It said that it wasn't contracting out of the Holidays Act and it was entirely discretionary. But I think the problem in this case, even though the court didn't come out so strongly to say that the short-term incentive scheme was used as additional consideration for an extended restrictive covenant for the employees who were going to sit within the scheme. So I think that was the problem, because it was a contractual hook into the scheme, elevating it to the status of a contractual entitlement. So if you can turn the slide for me there. So that just sets out the terms of the STI, which, as I said, was in a separate document. And you can see that they're really trying to carve this payment under the scheme as entirely discretionary. Payments are totally discretionary. There's no guarantee of any payment. Even if you meet the criteria, you might not receive a payment. This isn't a determined condition of your employment, and it doesn't fit within gross earnings for the purposes of calculating holiday pay. So really, they've had a good crack at carving it out.
It's been very specific. I was really surprised when I read this at how clear it was that it was outside of the employment agreement.
That's right, and that's the high watermark for drafting a discretionary scheme. Over on the next slide, we've just set out gross earnings, what that means. But basically, gross earnings currently under the Holidays Act means all payments that an employer is required to pay an employee, but it excludes discretionary payments. And over on the next slide, I've just set out what a discretionary payment is. And if I can just distill that gobbledygook down for you, it's anything that the employer is not bound to pay to the employee, but a discretionary payment is not a variable payment and it is not a conditional payment. So if you keep that in mind, you'll see why I think the Employment Court got to where they got to. So on the next slide, the Employment Court in this case was looking at whether or not the scheme and the payments under the scheme were gross earnings. They found that a term of an employment agreement didn't actually need to sit in the employment agreement. I think that would only apply if your employment agreement doesn't have a completeness provision. So if you don't yet have a completeness provision in your employment agreements, when you're issuing new ones, I would highly recommend it. And a
completeness provision, Jennifer.
It says that the terms and conditions set out in this employment agreement supersede all previous understandings and arrangements between the parties. So there is no dispute as to what is the operating document.
Mm-hmm.
And obviously, in this case, it was relevant that the participating employees agreed to an enhanced restrictive covenant. I think that's pretty fatal. So if you've got
just to be clear for us lay folk, restrictive covenant is a restraint of trade, yeah?
That's right. A restrictive covenant is a subset of a restraint of trade. So a restrictive covenant could be a non-solicitation of employees, customers, and non-competition, non-dealing. So it's a restraint of trade is the whole type of covenants where employees are asked to sit on their hands and an employer's got a period to re-establish their goodwill, which is not considered unfair competition.
Mm-hmm.
So the court said that was the extension of the restraint tied it to a contractual term, and that the scheme is intended to have contractual force. I'm not sure I agree with that analysis, but that is a whole nother discussion.
Mm-hmm.
I don't think that the court can infer the parties' intentions from a term. We all know that that's not the correct principles for contractual interpretation, but be that as it may, that's where the court landed. So over on the next slide,
we've got a question quickly, Jennifer, just on this. I think it's quite a good one too, and it says, would having a completeness term in an IEA clash with making house rules part of the employment relationship?
So we normally have house rules which sit separate from an employment agreement, and I always recommend that house rules are not elevated to the status of a contractual term, and you ought to have a completeness provision in your employment agreement, and you ought to have a policies and procedures clause, and the policies and procedures clause should say that we will set out our policies in a separate document titled handbook or code of conduct or whatever you want to call it, which may be altered by the employer on notice to you or written notice to you from time to time. So it's clear that an employer can vary the policies and procedures unilaterally without an employee's consent, and only, obviously you'll need to consult with employees as to what they are before you can rely on your policies, but we never like to elevate them to a status of a contractual term in any event.
Thank you, and that's gold. And for those of you that are MyHR clients, you'll recognise that, because that's exactly what we do. And when we go through the implementation process with you, we identify often employment agreements in place that say the counter to that. I'll say the house rules or the company policy manual forms part of this employment agreement, and we will actively encourage you to remove that and separate those two documents, and that policy clause that we recommend you insert references the policies in the way that Jennifer has just described. So that's a great question, and thanks for backing me up on that one, Jennifer. That's great.
You're welcome. You're welcome. We've worked together for too long. That's what that indeed tells me.
I know.
So very quickly, just on this slide, Metroglass were trying to argue that the scheme, because the scheme said it was discretionary, it must be discretionary, and it ought to be excluded from the definition of gross earnings. And you can see why, because of the way in which they drafted the scheme. But the employment court said, look, no, the definition of gross earnings is meant to capture all remuneration, and because there were criteria that needed to be met didn't mean that it was discretionary, and in fact we find that it's a contractual payment. And also the other point to note was that the employment court said just because you, Metroglass, have labelled the scheme as discretionary doesn't mean that it is discretionary. So we're really, and if you can just turn to the next slide there, Jason, on practical implications. This is the merging, I think, of the Employment Court decision and the Holidays Act Task Force report, which is back to a situation where gross earnings is going to cover everything. Something that is truly discretionary in the future, once the Holidays Act is changed, will still form part of gross earnings. So in the future, if you've got these short-term incentive schemes, you're going to have to draft them in a way where the payment of holiday pay is calculated within that quantum. So you might be reducing the quantum, knowing that a discretionary payment will form part of gross earnings in the future. And that's what this decision is heading towards. And I think that that's exactly what the task force saw. They weren't confident that the Court of Appeal would necessarily reverse this decision. So we need to brace ourselves for the fact that gross earnings will include discretionary STI payments at the very least in the future.
Yeah, and we've taken the approach to be ultra conservative. Now we describe discretionary as genuinely kind of random, as probably a bit, we've had a great year, it's Christmas, everyone gets a $500 bonus. It's never happened before, may never happen again, it's not written anywhere. It is completely sort of a director's decision or CEO decision out of the blue. But anything outside of that, anything that is more regular, or certainly anything that's written anywhere or that forms part of a program to encourage you to perform better in your role, that it will form part of the discretionary payment. It won't be considered discretionary and will form part of gross earnings for the purpose of the Holidays Act.
Well, that's right. Based on this decision now, basically the only sort of payment that is discretionary is the tap on the shoulder and the, cash in the envelope type bonus.
Yeah, right. Let's meet in the car park. Here's another great question. Would a profit share scheme, in brackets discretionary, potentially fall into the same realm as the ruling of this case in regards to it being required to be taken into account within the definition of gross earnings?
If a profit share scheme is crafted as some kind of incentive scheme, then yes, but if it's an employee share scheme, then that's quite different anyway. So if it's a productivity profit share type short-term incentive, then yes, that would be gross earnings for the purposes of calculating annual leave.
Yeah. But
employee share schemes are a whole different issue with different taxation rules.
Indeed, yeah. Thank you. Cool.
So the financial impact, you can leave it on that upcoming appeal slide, that's fine. But, this decision is, I think, currently has led and will lead to increased costs. And I know that employers are looking at the potential of wage arrears claims for the previous 6 years of underpayment, which is of concern to them. And employers are now changing their practices in advance of the task force recommendations that the government has endorsed, that all discretionary payments will now form part of gross earnings. The appeal of the Metroglass decision is being heard in mid-July, and that'll only be relevant to us insofar as this Holidays Act remains in force. But by the end of next year, I think it's a new landscape. Right. And that leads me to the only other case that I'm going to talk to, and then Jason is picking up, which is the Labour Inspector and MyHR decision. And Jason's asked me to talk to it just because it's an example of exploitative labour practices. And having read the decision, it was a Judge Perkins decision out of Hamilton at the end of 2019. And I was quite surprised that these practices are still happening. So we had a number of employees, 6 in total, who were the subject of this case, who'd worked more than 70-hour weeks. And after tax, they were paid $8 an hour. And the evidence in the case was that the partnership partners, husband and wife team, had a whole suite of rental properties that they'd purchased with the money that they'd extracted by not paying these employees. And the arrears total, which was wage arrears and holidays arrears, totaled to $250,000, which was remarkable. And the judge was scathing of the husband and wife team. said that it was clearly intentional to extract money, that once they were found out by the Labour Inspectorate, the husband and wife team made the payment to those 6 employees pretty quickly. But the bulk of the decision was about the penalties. And the penalties before discounting were 370-odd thousand. But the judge brought it back to 200,000 to bring it in line with cases, and the fact that the husband and wife team did make the back payment as soon as the Labour Inspectorate raised it with them. But really quite a shocking factual scenario. But surprisingly, the court has the ability to award to the victim some of the penalties that are imposed. And 2 employees got 20,000 each and the rest got 10,000 each. And I would have thought that, in fact, a lot more of that penalty should have been paid to those individuals who were clearly financially suffering and suffered significant detriment where they were sick. They were refused sick leave. Not only were they not paid for the sick leave, they had to then make up the hours that they didn't work while they were sick, and it sounds as though they were financially in a terrible situation. But that still happens in this country is frankly remarkable.
Yeah, it surprised me, and there's there's cases that pop up with alarming regularity, I think, and then there's this all the work being done now around modern slavery and some of the criminal cases that have been taken as a result of that. And yeah, I don't think we're as clean and clear as we think. I remember another restaurant case longer ago, and similarly the net earnings of the employees came into about $2 or $4 per hour. It was just crazy. So I don't think our audience do this. I can guarantee you that certainly no MyHR clients behave like this. But I guess the reason for kind of highlighting it in terms of is just there is now a real focus on unfair practice. And while I don't expect anyone to be this extreme, from time to time there are people who will want to try and figure out a shortcut or take a path of kind of I guess least cost, and in doing so maybe try and avoid some of their obligations. And our advice to you is just don't. It is our legislation is pretty clear. I really like it compared to, say, some of the complexity you might see in Australia, and that we establish this kind of baseline. And so work to the base and work above it, rather than navigating the modern award structure of Australia, where there's a million different rules depending on which industry you work in and which state and which city, etc. So it's not actually that complex, except for maybe the Holidays Act, to comply with some of those minimum entitlement or standards. Sorry. So yeah, that was the purpose of that. So thank you, Jennifer. Now, value tyres. This one's mine, yeah?
Mm-hmm.
So I'm going to talk way less like a lawyer here, Jen. So if I say anything wrong, you need to dive in and correct me. I guess the 2 things I wanted to really highlight here about this case was the reason for the award, the reason that the employer lost this one, and the amount that was paid, because there is definitely some relevance to the work we sometimes do when people contact us who want to talk about using redundancy as a means to perhaps exit an underperforming person, or as a faster and simpler way to move people out of their business. And the headline statement is it's not, and be very careful, because as we said right at the start in relation to COVID, redundancy requires some quite important things to happen, and there's quite a high threshold to demonstrate you have done those things. So we've talked about the substantive justification earlier, and we've discussed how COVID in itself doesn't justify. You need those details, and you need to be very specific about the details. In this case, the redundancy, if I'm not wrong, Jennifer, was found actually to be okay, but it was procedurally flawed. So this is, I guess, the opposite to those kind of COVID cases. The reason this employer wanted to lay off the Mr. Campbell was found to be actually sort of pretty much okay, but the process was flawed. And as a result, the employer had to pay, nearly $150,000. Right, so
118,000 plus 25 for hurt and humiliation.
Yeah, so what's what's my math? I'm an HR, I don't do math very well.
$143,000,
right? So, and look at the statement here. Although the restructuring was likely genuine, the decision not to redeploy Mr. Campbell was more likely than not driven by ulterior motives. So I haven't read the full case, but I read the articles in and around it. But the business was employing somebody from overseas that they knew. Am I right, Jennifer? It was a mate or a connection they had. They knew this guy. They knew he was pretty good at what he did. And he picked up the new role. And Mr. Campbell wasn't given the opportunity to consider or apply for that role. He was excluded from it. And so the redeployment or the lack of redeployment was driven by this ulterior motive, was found therefore to be unfair. So this goes to the other part of your redundancy process, which is process. So substantive justification is one part, the way you run the process is the other, and it's critical. And the redeployment piece is really vital. And what we tend to do, and I'm interested, Jennifer, and by all means criticize it because we're here to debate if this doesn't work, but what we tend to do when we advise clients around redundancy is once you get to this sort of point of the restructure where you've confirmed your new structure and you're looking at opportunities, lay out every vacancy. Now, you don't have to suggest that they are substantially similar, but you should be really transparent about the available positions in the business, from the receptionist through to the marketing manager. These are the vacancies that we have. We're being transparent and sharing those with you. And our role together now is to work in good faith to determine if any of these would constitute a suitable alternative to redundancy. Can you reasonably be expected to do them? And if they are too junior, the drop in remuneration, etc., may not be enough to justify the suitable alternative. If they are too senior, you may not have the skills, and you may not be able to reasonably develop or learn those skills in a time frame that would be considered fair and reasonable. So but we encourage our clients to lay them all out, just so there's absolute transparency. We're not hiding anything. Here are all the roles, and let's discuss what redeployment could look like. How do you feel about that?
Well, we probably take a slightly more tailored approach. So we would say, these are the roles that we've identified which may be suitable for you. And we cast that net quite broad enough for any employment court or authority to determine that, yes, those ones definitely are the suitable ones and probably a few extras. But we wouldn't ever say these are all the ones that are available and you can apply for X and Y, because the reality is people have got mortgage payments, they've got loan payments, they're used to earning a certain amount, and they, unless they're having a life change, they generally need to earn a similar amount. But that's ultimately a commercial decision for any client. And if any client said to us, no, we want to do that, there's no harm in that. But what they often will ask us to do for them is to map the roles which we think are legally suitable. And that is perhaps something within the same hierarchy, and then perhaps slightly more junior, slightly more senior. But that leads me to the next decision, which is relevant to briefly touch on, and that's the Wang decision on redeployment and retraining. So when you're looking at redeployment opportunities for employees, you must take into account that you've got an obligation to retrain, and that decision is the authority for the proposition that even if it takes 6 months to retrain somebody, that is still a suitable role. And that in that case, it was a more senior role, which the employer was required to upskill the employee into.
That's interesting, because we would normally set that threshold at 3 months. So there might be something we need to revise. But, in terms of what is a reasonable time frame in which to train a person to be fully competent, or sort of 80% plus competent in a role, that if they could do that within 3 months, 1/4 of your trading year, that's reasonable, and you should therefore consider retraining. I'd always thought that 6 months is a bit long, half a year. And I wonder then, because we tend to deal with businesses kind of 300 employees and below, and it's certainly in that smaller end of town, 30, 20, 10.
Yeah, that Wang decision was a small to medium enterprise, and the court said no, 6 months. And I frankly agree with you that 6 months is a terribly long time to upskill someone who's an accountant assistant into an accountant role. I mean, that business would have been struggling for a period, I would have thought.
Yeah, indeed. I mean, you've got the cost of training, and then the productivity.
It's the time.
Exactly.
Right?
Yeah. You'd actually have to employ somebody else more senior to do the role in the interim, contract out part of the work while the person came up to speed.
I'd still, despite that decision, I'd still have your rule of thumb of 3 months, because most small to medium enterprises can't withstand it. And I wouldn't have thought it's a reasonable ask of a small to medium enterprise.
No. Okay. And in making the decision, let's briefly touch on skills matrices. So you have a skills matrix that says this is the basis on which we're going to select people for this role.
Only if it's a downsizing scenario.
Okay.
Do you need that?
That's interesting.
So that's a whole nother topic, downsizing versus simple disestablishment.
Okay. Yes, and so you're disestablishing a role and there is no alternative, so there's no need to develop a skills matrix, but we are reorganizing. So we might be going from a leadership team of 10 to a leadership team of 6, and we're reorganizing and reshuffling the roles to better meet our strategic needs. Those 6 new roles, you would develop a skills matrix for, because they are new and different positions, and we are downsizing that team. Is that what you're saying?
So I'm sure this is where HR and employment law crosses over. So from an HR best practice, you'd probably do that. But from a legal perspective, the only point at which you must have selection criteria and a grading matrix is in a pure downsizing scenario where you're looking at 10 to 5. They're all salespeople. They're all homogenous roles. They're all at the same level. They're paid in the same pay band. And you take out from the position description the key competencies that are relevant. You need to consult with the employees on the proposed competencies, have all the feedback, finalise the competencies, have your panel then apply the competencies across each of the individuals. You'll form draft assessment results. They need to be provided to each individual and anyone else who asks for them, in fact, and that's another webinar, I think. Yeah. Then once you've finalised, after consultation, you've got feedback, you finalise the draft assessment results. The bottom 5 employees are made redundant. But there's no legal requirement for a skills matrix where you're necessarily mapping employees. So that can simply be, this is what we need for this role, and we think that person can be mapped into it. But as a matter of HR best practice, you probably would do that, and at least you'd have the paper trail to show that it was done in good faith and done appropriately.
And I think particularly we see where there are people who will be left out of that process and who like to feel that they should have had their say. And this is the space around that. They may clearly not have the skills, but they may feel pretty aggrieved at the fact that they're facing redundancy and will ultimately be made redundant, even though we don't predetermine the outcome, of course. But that if they've been able to participate in a process, view the skills matrix, put their hand up, or at least opt out, but opt out with full knowledge of all of the requirements of the role. We do find that when that person exits, they're less likely to then want to come back and have a crack.
That's the age-old adage, isn't it? If an employee feels as though they've been listened to and regard's been had to their views, then they're much less likely to bring a personal grievance.
Yes, 100%. Great little summary there. So we're coming up to we've got 7 minutes left. There are times we've sort of gone through this. I might, we've discussed that. I think if anyone has any questions, now's the time to probably start posting, because we will do a hard stop at 1:45. I was just going to close out by a discussion on sort of navigating problems in the workplace. But Jennifer, is there anything you want to say here? Anything you'd like to jump in on, or?
Just one thing that we're seeing, clients are coming to us more often these days with a question: do we need to conduct a separate exercise prior to commencing disciplinary action? And the answer often is yes. So we've got this case at the moment where a number of employees have complained to the CEO about alleged sexual harassment, a photograph allegedly being circulated of a woman with an alleged inappropriate photograph taken of an employee, a female employee. And the answer to the question is, well, you'll need to conduct a fact-finding investigation exercise prior to commencing any disciplinary action, because you've got such a mix of views, and it's not clear actually what transpired, that you need to first make a decision in relation to the facts by meeting with everybody, taking down notes, and making sure that each employee agrees that the notes of the interview are correct. Then you finalise what the facts are, and then and only then can you possibly use that to launch a disciplinary action. But in that fact-finding exercise, you need to ensure that you tell people that this isn't disciplinary, but if something comes out of this fact-finding inquiry that gives us concern, then we may be talking to you separately, so that you've certainly not fallen into the trap as an employer of being seen to have dealt with a situation when actually there may be further disciplinary consequences for other involved employees down the line.
Sure. So then when you, and I think this is really important, because we do encounter this reasonably regularly. But when you conduct that preliminary investigation, you've got the first sort of wave of information, and you need to determine what you then need to do with it. So you're not yet in this disciplinary process. This is the person at the center of it, and in your example, the person who shared the photo or took the photo, whatever it was. Should you suspend them on pay while you are conducting that, or is that now premature because you're not yet into a disciplinary?
Well, the test for suspension is quite different for the test for dismissal or a warning. So the test for suspension is whether or not the employee's presence will hamper the inquiry, or whether the employee's presence will prejudice the commercial nature of the business, i.e. if it's an alleged theft or fraud or inappropriate dealings with a customer, where the commercial standing of the business could be impacted. And if the person could hamper the inquiry, that means could they perhaps place pressure on other employees, not necessarily to give their version of events, or could they intimidate other employees if the allegations relate to intimidation or harassment, for example. But in this particular scenario, our advice has been that it would be too premature to suspend, because we simply can't determine what the purported facts are. There are too many competing versions of events, right, with too many alleged accused, that it would be too complex. So we need to hold fire, conduct a fact-finding investigation, and then make a decision. To be fair, however, the two young ladies who are particularly concerned with the alleged events have been granted leave to work from home, and they're taken out of the situation, so it's taken the heat away from it. But that was at their request, so it really answered the question, do we have to suspend, which is a good one.
Yeah, no, that's excellent, and that's good. We when people request to work from home, we make sure there's a paper trail, so it doesn't then later appear to be that they were kind of
an unlawful suspension.
Yeah, an unlawful suspension. And just a quick note on suspension, folks, because again, we do sometimes, unfortunately, get phone calls when people say, right, this has happened and I sent him home, he's on suspension. And it's at that point, there's not much we can do, but please remember you need to propose suspension. They are entitled to consider the suspension proposal and give a response before you confirm. If it's an extremely volatile situation, you're able to separate people, so things calm down. I use the example in a warehouse, and Jennifer, you'll know this place, but an employee took to another employee with an iron bar. And so absolutely we had to separate them and remove them, and then we engaged the union, and then we proposed suspension and sent them away. So it's not about having to keep everybody together, but just don't go in and shout at them and send them home and then believe that you've successfully suspended somebody, because that will all unravel further down. Now, look, I've
just got one more point, Jace, just on that. I know you have to wrap up in 2 minutes.
No, we've just got a question too, but you go.
Just very quickly, if you do need to get rid of someone quickly and you don't have time to give them an opportunity to consider the suspension, get a representative, hear their feedback, and then suspend, and that can take half a day, right? You can always go to the employee and say, look, this is getting difficult, we need to investigate it, would you be prepared to take some additional paid special leave? And if the employee says yes, then you'll email them straight away and say, thank you for that, you've agreed to take additional paid special leave, we'll come back to you when we're further down the track. So that's another way of doing it effectively and not breaking the law.
It's a nice little lawyer's trick. I'm going to remember that one. We don't. Okay, cool. Thank you. Write that down, folks. Okay, here's the question, and then we will have to wrap. The question is there anything we can do when we have an employee who goes straight to filing a formal PG and doesn't talk to anyone in their organisation about their issues first?
Well, I mean, I would just deal with the PG as it comes. So if you receive a PG from an employee, then you need to take it seriously. You need to investigate it. Presumably at this point, it's either an unjustified disadvantage and they're continuing to work, and you might try and resolve the issue, investigate, go back to the employee, respond in writing, go to mediation services, try and repair the relationship. Or alternatively, it might be someone who's resigning, claiming constructive dismissal, and then they're out. So you deal with it once they're gone, usually.
Yeah. Sometimes, Jennifer, what we would do if we see that if it appears to be genuinely sort of speculative and genuinely out of the blue. So here's a PG. I'm telling you all these things that you never knew about, and I've never talked to anyone in the workplace about how I feel or about what's been going on, and now I'm going to hit you with all of these things, but you actually don't believe any of it's happened. We will sometimes be quite direct. I won't say aggressive, but direct in our response. And go so far as to sort of describe actually what happened, and that we didn't know you haven't acted in good faith because you haven't given us the opportunity to investigate any of these claims or repair them, and that on the basis of this that we would be willing to do so, but we don't agree to mediation because it's voluntary, and kick it back to them and go, well, if they're serious about it, and this is not just 0800 SACT having a no win, no fee crack at us, well, then they're going to have to raise a statement of problem. They're going to have to go through a process. And yes, we may get directed back to mediation, but in fact, we may not. It might go away at that point. Just to sort of shut it down if it's completely out of the blue and the claims appear to be really quite baseless, we would do that sometimes. How do you feel about that?
Excellent.
Oh,
good suggestion.
You were silent. Oh no, too aggressive. Yeah, no, and sometimes they do. I think on the basis that what your SACT Kiwi or 800 SACT folks take 25 or 30% of whatever settlement there is, they just want a quick settlement. They're not.
That's right.
They're not being paid for their work. They want to send you an angry letter, scare you as much as they can, get you around a table and extract as much money as they can for the minimal amount of work. The quicker they get a resolution, the higher their hourly rate is pretty much how that translates. So, yeah. So hopefully that answered the questions. Look, we are now a little bit over time. Thank you so much, Jennifer. That was awesome. I look forward to doing this on stage with you one day, and we can kind of carry it on. We can answer questions live in the room. And if you do have any questions after the event, feel free to get in touch. So thanks once again, everybody. Great to virtually see you all. Take care and stay safe. Bye-bye.